Hello, good morning, and welcome to our webinar, 10 Basic IP Tips for Doing Business in China. My name is Peter Siegel. I'm here with you on behalf of the China IPR SME Helpdesk, and I will be your moderator for today. I don't want to waste too much of your time before we get into the thematic content of our session. So I would like to briefly introduce first the webinar interface. I'm not sure how familiar you are with GoToWebinar. As you can see on the slide, there is a little webinar toolbar which is the most important part. You can type in your questions that our IP expert will get and will be able to answer you at the end of the session during the Q&A. And if we can go to the next slide, please. First of all, I would like to introduce our help desk. We are an EU-funded initiative helping EU SMEs to protect their intellectual property in China and to provide confidential advice on any intellectual property related issue. We have various free services. It's very important to underline that as we're an EU-funded project, all our services are completely free for SMEs. First of all, we have an inquiry helpline that is accessible on our website or by email, through which EU SMEs can submit all their inquiries to our IP experts, which will be answered in 3 working days and of course treated confidentially in accordance with all EU data protection guidelines. We frequently organize training workshops, which are unfortunately a bit on hold during these challenging times during the coronavirus, but will resume after things get back to normal. In the meantime, we organize webinars like this one. We also have a blog, and we have various printed guides, business guides, fact sheets, articles written by our RP experts on our website. And now, with no additional delay, I would like to introduce our 2 speakers for today's webinar. Firstly, Ms. Gwen Song, who is the Executive Director of the Flanders-China Chamber of Commerce, and Matias Zubimendi, who is our IP Business Advisor for the China IPR SME Helpdesk. And they will present today's topic and provide you with a more in-depth information about how to protect your intellectual property while doing business in China. Here you can see the agenda on the slide. And now I would like to give the floor to Ms. Gwen Song to introduce the Flanders-China Chamber of Commerce and to provide you with a brief overview on her organization and the presenters of the webinar.
Good morning, ladies and gentlemen. On behalf of the Flanders-China Chamber of Commerce and the EU-China Business Association, I also warmly welcome you to our webinar focused on 10 basic tips to succeed in China. Today, we are experiencing very difficult times as a result of COVID-19, and China is recovering from COVID-19, and the fact that the 2 important sessions of the People's Congress have been confirmed to take place tomorrow means that the Chinese government is confident that they have the COVID-19 under control. It is a key marker in China's process of getting back to normal. Despite COVID-19, every company should have a China strategy and see how they can work together, whether by exporting, licensing, investing in China, or supporting Chinese partners in our own country. It is important that companies prepare themselves well in advance and protect themselves. China became the world leader in international patent filings in 2019 with about 58,000 applications, overtaking the US. And for the 3rd consecutive year, China-based telecoms giant Huawei Technologies topped the global ranking in 2019. Despite COVID-19, there is also still enormous untapped potential for growth, and the EU and China will be having the 29th round of negotiations on the EU-China Investment Agreement, which offers an opportunity to increase trade and investment. It will offer new and better market access for investors in the EU and China, and the aim was this agreement to be signed in 2020, and we hope that is still the case, because as a result of COVID-19, there has been some delay in discussions. Speaking about innovation in China, we should really think, what can we learn from China? China has already become a leader in innovation in several areas, such as the internet industry and artificial intelligence. And also today, in tackling COVID-19, we should really think what we can learn from China. Let me say a few words about the EU CBA's role and activities. So the EU CBA is the EU-China Business Association, which is the association of bilateral China business associations in the EU, aiming to promote the economic and trade relations between the EU and China. Today we have 19 member associations and represent more than 20,000 European and Chinese companies, and the aim is to be complementary to the national level so that the member companies can work on a larger scale and deepen their cooperation with Chinese business partners. The Flanders-China Chamber of Commerce is a member of the EU CBA and supports companies doing business with China. We are at your disposal for any further information, and I wish you a good conference. I would also like to say that we have our next webinar planned on best practices in R&D in China in June. I wish you a successful conference. Thank you. I would like to give the floor to the next speaker now.
Thank you very much. And then we will move on to the next part of the webinar, the thematic part. And I would just like to reiterate that all the slides on this webinar platform will be available on the China IPR SME Helpdesk website from tomorrow onwards. So you're more than welcome to visit the website, download the webinar slides, listen to the webinar recording, and also you're more than welcome to discover the various services that we offer. Before I would like to give the floor to Matias, I would like to engage the audience in an interactive exercise, so to say. We would like to ask you 5 very simple questions through the webinar platform, which you will be able to see on the polls button. And the purpose of these questions is for us, the project team, to assess the usefulness of this webinar. The same questions will be asked from you after the webinar ends. So before the webinar content and after the webinar content. This is how we will see that the issues that we aim to address were effectively addressed. So without due delay, I would like to pull up the first question. Can I present my invention in the trade fair in the region before applying for a patent in mainland China? Kindly select either yes, no, or I don't know. I will wait for around 30 seconds, 1 minute. Okay, thank you very much. So far, half of the respondents have voted no. The next question. Start using my trademark in mainland China is enough to ensure my rights on it. So it's a first to use system. Please select whether you think this is true, false, or you don't know. So far, the overwhelming majority believes that this statement is false. Okay, thank you very much. I think this gives us a clear picture. Next question. Each product can only be protected by a single intellectual property right at a time. Please select whether you think this is true, false, or you don't know. Okay, most of the people think this is false. Next question. In mainland China, I can present the registration documents for my IPR in English. Please select if you think it's true, false, or you don't know. Please mind that we're talking about mainland China here, not Hong Kong, Macau, or Taiwan. Okay, almost 2/3 of the respondents think this is false. And finally, the last question. I do not need to appoint a local IP attorney to register my IP rights in mainland China. Okay, thank you very much. Again, almost 2/3 of the respondents think this statement is false. These were the 5 questions. We will send you the same questions after the webinar, and we are interested whether the contents of the webinar have made you change your mind regarding these questions, whether they increase your knowledge on the topic. Sorry, I would like to introduce now our second speaker, Matias Zubimendi. Matias has a master's degree in Chinese civil and commercial law from Peking University, and also in intellectual property law from Austral University. Prior to working with the China IPR SME Helpdesk, Matias had various roles as intellectual property a lawyer in various legal firms, and most notably he was director of legal affairs at Conquer Europe. Apart from his professional endeavors, he's also an active academic, giving lectures in various conferences and also acting as a professor assistant. So without due delay, I would like to give the floor to Matias now.
Thank you, Peter. I have control of Do I have control of the slides now? Let me see. Yes, perfect. Hello, everyone. Welcome to the presentation of 10 tips of IP to protect IP in China. I would like to start with the most important one, which is to anticipate, to prepare in advance if you want to enter the Chinese market or you're planning to do business in China. Anticipation is the key of everything. The first thing a company should take into account when deciding to do business is to prepare an IP portfolio. This is to analyze what IP they have. They should analyze the patents they have, how many, in which territories they have, what technologies are protected, and who is the owner of these patents. When analyzing patents, they should analyze invention and design patents as well. And they should take into account that they may have a potential patent that is not registered, but it could be. And it would be a good idea to organize a meeting with the employees in order to analyze the production process, to study the current existing technology in the competitors, to analyze the state of art in patents, and decide if there is a possibility of a new registration. They should also analyze their trademarks, especially organizing and classifying the different trademarks and the different brands the company is using. They should identify which one are more important. By this, I mean the name of the company, the product names, the logo, but because companies may have secondary trademarks that are related to only few specific products, they should identify which one are common to all of them. They should also analyze if they may have some copyright, for example, software or database. They should consider trade secrets. Trade secrets are sometimes forgotten by companies. A trade secret is every information that is kept as a secret, that has value for being secret, and that is protected by protection measures. These trade secrets may contain the possibility of a patent registration. So companies, when moving abroad, they should be very careful in order to keep this trade secret as secret. For doing this IP portfolio, companies should or can hire experts in order to make a patent or trademark search, to check if the trademarks are available in this case in China, or if there is any bad faith registration, and consider their strategy according to taking into account this information. Besides that, they should also analyze their competitors to see what IP do they have, how are they producing, what products are they selling, in order to identify if your own company has any competitive advantage, how it would be to enter the market, how many chances you have of succeeding. Also, companies should analyze e-retailers, because in China, e-commerce is way more developed than in the Western countries. So companies should get familiar with Alibaba or Taobao to learn the rules, to learn the business culture, because this way the companies have more chances to succeed. This is a new market, a new completely business environment, and to anticipate in the sense of to learn in advance how to deal with this in this scenario, it is very, very important. My second tip is to create a strategy, a business strategy with Chinese characteristics. This is you learning how to sell properly in China. The best way to do this is first getting familiar with the local law and regulations, because even though IP laws are quite general worldwide, there are some specific differences between the EU and China that could have an important impact. For example, in China, only registered IP is protected, while in the EU, many times, for example, with trademarks on design patents, non-registered IPs, they have certain level of protection. In the case of design patents in the EU, the ones that were used but not registered, they have protection for a period of 3 years. While in China, when the IP agency is checking the novelty of design patents, they require a full global novelty. This is if the company use the design of a product in any moment, in any place of the world, they cannot register the IP. Also, another important difference is that in China, the protection becomes with when the registration is granted, while in the EU, in many cases, when it's filing, it was filed. So there is no protection in China while the IP right is in the process of registration. Another important aspect is the translation of trademarks. It is very common for companies to translate their brand name into Chinese characters, because in general, and this is something that is changing because the country is developing and the people are more and more learning how to speak foreign languages. But there is a huge amount of consumers that are not able to read Western alphabets. So the way to deal with this situation is that companies translate their brands, the trademarks, into Chinese characters. They do it in two different ways. In a literal translation, they translate literally the name of their brand into the Chinese word. Another option, or the most common one, is a phonetic translation. This is, they replicate through Chinese characters the pronunciation of the Western brand. But in this case, it is important to know that every character that companies use in order to do this phonetic translation actually contains a deep meaning. It is very interesting the case of Coca-Cola, who translate the brand, the name Coca-Cola, to Coca-Cola, that contains 4 characters. 2 of them are the same, but the meaning of them gives positive ideas. The first one and the third one, the meaning is about the possibility to be able. The second one refers to the mouth and to everything that is eaten, drinking. And the last one gives the idea of happiness. So the full name contains the possibility of drinking something and the possibility of giving happiness. As you can see, the name was not only a phonetic translation, but also gives positive feelings, positive aspects that in the sense of marketing, it is very important to take into account. It's when translating a trademark to Chinese, companies should take into account what are the main concepts they are communicating with the trademark. Also, it is important to create a strategy understanding the local business culture. And many Western companies are not used to the use, for example, of WeChat. Chinese business culture takes place online mostly. The importance of WeChat and it's a key, because many of transactions happens there. Even payments can be done there. In China, the business culture, it's in a sense informal, but it doesn't mean that it's chaos, because it is extremely efficiency. It looks informal, and it is informal, but at the same time, this informality helps the efficiency of how everything is organized. It is very fast, it changes all the time, it needs a good capacity of adaptability in order to succeed in China. So companies should start to learn and understand how this business happens in China. My third advice is to find professional support because of the language barrier mostly. But in order to overcome this language barrier, because if you go to China, all the official language or official agencies will talk, and all the processes will be only in Chinese language. It is important to have a Chinese native speaker professional. However, there is a possibility of having certain protection or getting certain protection from your own country. For example, with the PCT agreement in the case of patent, on the Madrid system in the case of trademarks. Companies can go to their local IP agent, ask them to file a trademark or a patent, and through the PCT or the Madrid systems, they may require to include China as one of the protective countries. Sorry. Also, it is important to find a good local professional team in China. So when the company is landing in mainland China, they have some people to rely on, that they can do translations, and this is particularly important when filing a patent, because when writing the claims, which are the main scope of protection, it is very important to have them well written, because they should include all the technologies that will be protected. And also because to those companies that do not have any address in China, that they didn't settle there yet, or they don't have the business license, for them it will be necessary for any kind of protection, including trademarks and copyright, to count with the local IP lawyer. Also, companies should start networking with embassies and chambers of commerce, because they are a good source of contacts. Through them, it is possible to get meetings with Chinese governmental authorities, also to know other companies that may share the experience, that they can collaborate with your company. They could be partners. It is a very good source of networking, and since China is a very different business culture, it is good to count with some help and some people you can rely on, and they speak your same language and they have the same ideas, and maybe they have more experience than you. In the China IPR SME Helpdesk, we have a guide about how to find an intellectual property agent, and also we can help with informing which companies are, or sorry, which governmental offices and embassies and chamber of commerce are available. My next tip, it is related with the rule of first to file. In China, as I mentioned before, only the IP that is registered is protected. So it is very important to file the IP right first. This is very important in the sense of when an intellectual property right was filed, it is very difficult to take it down, even if it was a bad faith registration. So for those companies that are considering going to China, they should register in advance. This is not sending the products with the trademarks to China and then do the registration. First the registration and then sending the product. Even if a company is going to a trade fair, they should register in advance the IP, because in trade fairs there are a lot of companies seeing each other, analyzing each other, seeing possible business ideas, and this is a moment where companies could see your brand, see the potentiality, and do a bad faith registration. Also, it is important to take into account that if you go to a trade fair to show a prototype, but you don't have the patent, you should not show the prototype. because one of the essential requirements to patent protection is the novelty. This is that no one knows the product, and if you show your prototype or your product, the novelty will be ruined. So before attending to a trade fair, it is essential to have trademark, patent, and designs protected, even copyright if it is the case. Also, it is important to have a comprehensive protection of intellectual property rights. Let's say each product or each aspect of your product can be protected in different ways. And nowadays, there is a new tendency that we realize that is happening a lot, that for e-retailers, when a company wants to sell their products, the e-retailer is asking them for a valid certification that proves that they are the IP right owners. The most common way to show this is a trademark certificate, but in certain cases, the trademarks are already registered, so bad faith sellers, they cannot show the trademark certificate. But to overcome this problematic, what they are doing is to register the logo or the name of the company as a picture, as a draw in the copyright office. So they actually obtain a copyright certificate, valid certificate from the Chinese Copyright Agency. They show it to e-retailers. They're saying, I have the certificate that proves that this was made by me. And e-retailers are accepting this valid certificate because it is actually valid, and they're able to sell online. So what they are doing is overcoming the trademark certification with the copyright registration. So when companies are thinking their IP strategy, they should take into account every possibility, and they should do a comprehensive protection. This is when a company is filing a trademark, they should also, nowadays especially, to consider doing a copyright protection. And taking into account the prices of the fees, this is very advisable because it doesn't increase much the cost, and a copyright protection, it's around 100 RMB. What happens if a company do not register in advance? It may end up in the loss of IP, as I mentioned in the case of patents. If you show your product in a trade fair, it could end up in a bad faith registration from a third company. In this case, the IP is not totally lost, but it will delay the entrance to the Chinese market and increase the cost considerably, and also it could lead to new competitors. The fifth tip is to make effective contracts. Companies should prepare the contract strategy in order to gain efficiency. The first thing they have to take into account is non-disclosure agreement and non-competition agreement. When they are dealing with a third party, it could be Chinese or non-Chinese, this is actually the same. They should include non-disclosure agreements. This is to protect trade secrets. This way, the third party that get access to certain information, or a prototype, or a trademark, or a product that was not released, they have the duty to keep it as a secret. This way, the novelty of a patent is not lost. And in these particular contracts, because of the potentiality of damage in the case they leak some information, it is important not forgetting to include the damage clause in the case of a leak of information. Also, it is a very good opportunity to make it clear that the IP or the information that the company is showing and sharing, that the company is the ownership of that IP. It is possible to create a non-disclosure agreement that is general, where it is said that every future information that will be shared should be considered as a secret. It should be kept confidential, and all the intellectual property rights belongs to the company, and also that the company, this third company, cannot compete with our company, and also that they cannot develop new technologies over the technologies that we are sharing, at least without our confirmation and authorization, but also without giving us the chance of being the owners of that technology. Maybe not for free, because that would be abusive, but having a priority to obtain that technology. Another way of making effective contracts is through licenses. With licenses, companies have the possibility to exploit non-use technologies, or those technologies that are useful for your company, but they can be also useful for companies from a different sector that are not competitors. It could be a good way to obtain certain profit from them. There are two different ways of licenses for that it is possible to describe. There is one that is called the carrot license, or the sale of IP. This is a company identifies a third party that can obtain certain benefit from the use of our technology. For example, we have a new production method that is useful for us, but it can be useful also for a non-competitor. So we approach to them and we say, we have this technology, we think it can be useful for you. For this amount of money, we can let you use the technology. This is a friendly approach. But there is a second approach that is called the stick license. That happens when a company identifies that a third party is using the technology without paying any fees. So the company approached them and said, we identified that this is going on, that sadly you're using our technology. We know it's a mistake, but we don't want to stop you doing business. So this is the fee for our technology, and instead of becoming enemies, we can become partners. This strategy, it is particularly important in the case of China, since SMEs in many cases, and especially I think in the near future after this COVID situation, they may not have all the resources to face an enforcement strategy in China. The lawyers' fees sometimes are very expensive, and it takes a lot of time. So instead of litigate, instead of creating a problem and getting into a very problematic situation, I think a good approach or a good strategy that SMEs should take into account is the possibility of getting new partners with licenses. Approach to them and negotiate a license. This way it is possible to obtain some profit, but also to avoid a very difficult and expensive situation. Also, it is very important to set clear the IP ownership, or any time that the company is sharing products with a third company in any scenario. This is for the current IP. This is the trademarks, the patents, the copyright that we already have, but also it is important to make clear who is going to be the owner of those technologies or future brands that may come in the future. For example, for franchise, because this is a very usual scenario where a franchise is opening their first shops or places in China. They are adapting their products to the Chinese culture, maybe with the translation of trademarks, or simply making new marketing and getting new services to adapt Chinese consumers. And this may contain certain IP, and this IP belongs or happens only in China, and it was developed in China. And the company should make clear that these new developments belongs to the owner of the franchise. But this is also something that we will talk about in our next webinar next month, that belongs to research and development. My next tip is to create internal IP policies. This is particularly important for those companies who are settling in China, not only doing business, because they are required to do a handbook of employees. It is a good opportunity to create protocols for employees about how to deal with IP, how to manage it, how to proceed in the case that they identify a new potential, for example, patent. And this way, the employees will be able to identify, protect, and communicate to their superiors about any potential business idea. This also should be complement with IP training. This is with education to the employees, that in many cases employees do not have education about how to deal with IP. So they should not only be these protocols, they not only should be specified in the handbook of employees, but also specific training should be provided. This is particularly useful for trade secret protection, because as I mentioned before, the trade secret can be protected as long as it remains as a secret. So this means that the trade secret should be protected with different measures, that they can be from physical measures, for example, stamping a document saying that the document is confidential, like the stamp that you can see on the screen. Also with contractual measures, for example, with the non-disclosure agreement that I mentioned before, but also with internal IP policies. And here there is a very important rule, that is the need to know rule, that companies can adopt. The need to know rule means that an employee only should have access to the confidential information that is necessary for him or herself to develop his or her job duties. This is the employee only should have access to the essential information that he needs for working. If, for example, there are different research teams that they are parallel and they don't need to interact within each other, then it is not important for one to know the research of the second one. In this case, it is possible to set a rule that information related to the prototypes or the research cannot be shared between both teams, because they don't need this information in order to perform their own research. This way, there is a tendency of reducing the possibility of a leak of information. In the case of trade secret protection, it is a practical field. The information should remain as a secret at almost any cost. So the protection should be sought not only casually and considering that a contract it's enough, but also the information should be actually kept away from third parties, in the sense of if a company has visitors, they may take pictures, they may record. So it is very important to keep the information secret. My next advice is to avoid unnecessary litigation, because litigate in China it's expensive, it is difficult, and in many cases the results may be uncertain, because the IP judicial culture, it is improving a lot, because now there are several IP specialized courts. So in the main cities like Beijing or Shanghai, we can say that it is very advanced now. But in the countryside, the IP protection may not reach the standards that European companies are used to. So my advice is to avoid unnecessary litigation. And for that, when thinking the enforcement strategy, the company should take into account the three possibilities that they have. The first one is this administrative enforcement, that it is before specialized administrations, for example, the Chinese National Intellectual Property Agency, but also in the Chinese customs. These administrative enforcement usually are faster and cheaper than civil enforcement, and they have certain efficiency in the sense of it is possible to stop and export shipment. It is possible to confiscate. It is a good way to obtain evidence for a later civil enforcement. But in this kind of ways to litigate, there are no damage compensations, so companies would not get any profit. They will not be paid for any loss. For doing that, it is necessary to go to civil enforcement that goes before people's court, or in certain cases, they could go to, as I said, IP specialized courts. However, civil enforcement, it's only advisable for the most difficult cases, because they take more time, they are way more expensive, and the final outcome may not be so clear at the beginning. However, the pro of civil enforcement is that it is possible to claim the lost damages, including attorney's fee. So at the very end, the company will get some profit. However, during this process that actually could take several years, it's going to be only lost for the company. So companies should take this into account. It is possible to combine both administrative enforcement with civil enforcement. As I mentioned, administrative enforcement, it could be used as a way to obtain evidence for a later civil enforcement. Finally, there is the possibility of criminal prosecution that is only for prosecute a bad faith seller, but this will not involve any kind of civil compensation, but more of taking away a potential competitor. My next advice is to have an affordable IP enforcement strategy, because as I mentioned before, these litigation processes can be very expensive, so companies, especially SMEs, should take into account that to analyze if they can or they cannot afford a long litigation process, and to analyze what are the different possibilities, the different approaches they may have to avoid this litigation. As I mentioned before, we have the carrot license and the stick license. That means that I repeat myself, but I think it is very useful to take into account this approach, that to transform a potential enemy or a potential competitor into a partner, giving them a license and allowing them to keep doing businesses, but is in this case paying the proper royalties. Also, companies should know how e-retailers work and learn the online enforcement method. This is the notice and takedown system. Company can identify products that are being sold online, and through the system that belongs to the e-retailer, they can notify them and they will be removed. Normally, this method is very efficient, and within 48 hours, the products are removed from the platform. This method do not stop the seller to keep selling, because actually only the actual offered product is removed from the platform. However, it is way more cheaper, since it only requires someone in front of the computer, maybe the presentation of certain documents like a trademark, and it would be removed from the platform. So it is a good approach to take into account. The third method is to start and to learn to negotiate with Chinese partners in order to, as part of the IP strategy, and to avoid going to court, trying to reach an agreement that could be a license or not, but to negotiate with bad faith sellers. It could be done with the assistance and advice of chambers and embassies that may help to overcome, for example, the language barrier. Also, when deciding the strategy, companies should be result-oriented. I think a good example of this is the registration that can be done in customs, the registration of a trademark, for example. So company can register their brands with customs, so they can check when a product is being exported, and they can stop it, notify you, and this way companies can control, for example, if a seller is trying to reach new markets. That's why it is very important to have the IP in China, even if China is only the producer country, because this way maybe the company has no interest in the Chinese market, but they are selling in Europe, but the products are coming from China. So if a trademark is protected in China, it is possible to do a custom registration, and it is possible to avoid the producer to start selling to third markets, for example, Latin America. This way, the company not only protects the main market, but also protects different other markets that they may be interested in the future. The ninth tip is to learn how to do a due diligence and how to learn about getting information about Chinese companies, and when analyzing if they want to do a partnership, and what are the risks, what are the potential benefits, and how to overcome in general the language and cultural differences. The language barrier it's I think the most critical aspect, because it's very difficult to understand each other if there is no interpreter, and even with an interpreter it is difficult because of the cultural differences. So to overcome this language barrier, it is, I think, very important to have local attorneys. It's even better if it is a very international law firm, because sometimes they do have foreigners working, and they are able to, it may be the case that they are even capable, they're even native speakers of your native language, so the communication is way easier. Also, it is critical to have the support of embassies and chambers of commerce, because they can provide assistance, and they can help you to check documents, and if there is any kind of problems, they may be able to explain what are the reasons of that problem. And also, companies should learn how to do companies research, how to search for information that may be available for public. There are several websites for doing this. In the case of the EU Chambers of Commerce in China, we provide a guideline that now is in the process of being updated about how to do a company research, how to obtain information, but also we provide this service in the case of if some of you is interested. And finally, how to learn how to deal with this intricate bureaucratic system that China has. Actually, every country has bureaucracy, and it is not a very pleasant scenario to deal with bureaucracy. But because of the language barrier, it can become even more difficult to overcome and very uncertain. So it is good to know in advance what are going to be the necessary documents, what are going to be the steps, the time that certain permission or authorization will require, to look for experts in this kind of procedures. And again, the support of embassies and chamber of commerce, it is very useful. Here there are some key questions that company may ask to itself, or may ask about a third company in order to do a proper due diligence. You will be able to read them now, but also when downloading the presentation. So I'm not going to go one by one, but only saying that the critical aspects are to identify what are the intellectual properties involved, who is the owner of them, if there is any license, what are the limitations of the license. That could be limitations on times or production. If there are some pending registrations, what is the potential outcome, sorry. And also to take into account the actual, especially in the case of third companies, the actual IP enforcement and how many bad faith sellers they may have in the specific market, in the case China. And my last tip is for companies is to learn to adapt and overcome, to take the opportunity of a new market and see it as a chance for improving not only those products and services that are going to be offered in China, but also in your home country, since it is a new business environment and that is very informal but efficient, that change a lot, that requires different skills. I consider it's a good opportunity to learn, to get new partners, get new ideas, develop new products, maybe to adapt and improve your business plan, to develop new intellectual property, not only patents, but maybe also trademarks, to realize that the consumers have certain interests that they are very common in Asia, but they can also work in Europe, and bring them to Europe, bring to the EU some Chinese solutions and use them in the EU. For example, I think the most remarkable thing of China is the payment methods that are very, very convenient, and I would love to see them in the EU. I think there are plenty of opportunities like this that companies can learn and bring. And finally, it's a good opportunity for companies to expand, to be more efficient, to offer new services. I think they should take this challenge as an opportunity and go to China prepared, with anticipation, but with an open mind. If you want to contact us, we offer a helpline that is free, fast, and confidential. We reply your questions within 3 working days. And if you have any doubt, any question about IP protection in China, it would be a pleasure for me to help you. And our next webinar is going to be the 17th of June about research and development. And I think now Peter is going to take control of the presentation.
Now I would like to advance to the questions and answer sessions. So if anybody in the audience has a question regarding the presentation or any question regarding intellectual property rights in China, please feel free to use the chat window in the webinar panel, and we will be able to gather all the questions, and Matias can address them. We will wait a couple of minutes to collect all the questions.
Okay, I'm receiving the first questions. Let me see. Would it be possible to explain time frame and cost to register IP and approval? Yes. It depends on a lot of what kind of IP we are talking about. Copyright is around, it depends on how long the work it is, but generally speaking, it's around 100 RMB for a single picture, and it's a deposit, so it is automatical. In the case of trademarks, the fee is 300 RMB for each class. Trademarks, I didn't explain this, and you may not know, but trademarks, when registering a trademark, you should identify a class. This is what kind of products are we talking about. For example, class 25 belongs to clothes, and each class has different subclasses. For example, in the case of clothes, you have t-shirts, trousers, shoes. Each one of them is a different subclass. So it's 300 RMB for for up to 10 subclasses. Then if you want to keep adding subclasses, it's 30 RMB for each one. In the case of patents, I don't remember exactly the fee, because in the case of patents, it's way more expensive because it always requires an expert intervention. So I would say that in general is between 10 and 50,000 euros in general. Patents are way more expensive. And the time frame in the case of trademarks is around 1 year. This is another difference because in Europe, it depends on every country, but in general is a few months. In China, it's a whole year. And in the case of patents, it's between 3 and 5 years. And because there is no protection during this registration period of time, it is a very common technique that companies do is to register at the same time trademarks and utility models that are also called small patents. Sorry, patent and utility models. That utility models are called small patents because the requirements for them are pretty similar, only that they are less demanding. They are easier to comply with. And the utility models takes around 1 year. So companies do parallel registration of patent and utility model in order to obtain the utility model in 1 year, using that protection till the moment they obtain the patent. And when this happens, they discard the utility model and keep using the 20 years of protection of the patent.
Thank you very much, Matias. We received another question.
Sorry,
go ahead.
No, please read
the question is, how is it possible to enforce IP licenses after the agreement? Is it via auditors? How to check sales volumes of the licensee, and what do these audits cost?
Okay, let's go one by one. How to enforce licenses? Well, when there is a license, the company should make surveillance if there is any violation of the clauses. In this case, the first method is to cease and desist letter done by your lawyers and request to stop doing whatever they are doing that goes against the agreement. And if there is no result, there is no negotiation, the next step is litigation before people's court. This is the steps. What was the second question, Peter?
How to enforce the IP licenses after the agreement? Is it by auditors, and how to check the sales volumes of the licensee?
Okay. It could be done with auditors. As I said, the company should do surveillance, so this can be included in the contract how to do it. It is possible to include clauses that allows the company to do regular controls, and this way your company is able to check. It is a very sensible topic, and it's not an easy thing to do because this is actually the main difficulty, how to control. So as I said, anticipation is the key, and a good written contract, including methods of surveillance, it's a good technique. To control the production, I would say two different approaches. The first one is what I mentioned before, including certain technique, could be with auditors, or for example, having the possibility to check when some shipment is going to be done, to actually need the final confirmation of the company to do it. But I think the most efficient technique is with trademark registration in customs, and working with in combination with the assistance of chambers of commerce to let customs know when products with your trademark are going to be exported, to let you know, so you receive a notification, and this way you can track how many products are leaving the country. This is a good technique that can be used and gives you from the certain information from an official authority.
Just a follow-up question that we received from the original poster. Is it possible to check the export data provided by the Chinese government? And also, what do these audits cost?
The export data? What do you mean export data?
Could you please, Mr. Demon? Yeah, thank you. Export numbers from a certain supplier.
Export numbers. I actually don't know what's. It is possible to obtain certain information from experts. There are certain websites that gives you information about companies, and they can be they include a lot of certain information. I don't know if this replies the question. That I don't know what is exactly what kind of information he's looking from the company.
Maybe I could advise the poster of the question to get in touch with the help desk using the query or our email address, and he can get tailor-made replies.
Okay, yes, that would be better.
Yes, so if there are no more questions, with this I would like to conclude this session. Thank you very much for being with us today. You're more than welcome to ask us any questions on our website and also on our email address, question@china-iprhelpdesk.eu. And we're looking forward to seeing you during our next webinar on the 17th of June, same time, 10:30 in the morning, Brussels time. So thank you very much for being with us today, and hope to see you soon.
Thank you, everyone. Bye-bye.